Hi, everyone. So we're just going to give it a minute or two to let people join before we start, and we'll officially join at 3:02. So feel free to make yourself comfortable or, get any resources, get your questions ready. And we're really, really excited for this discussion. Thank you so much. Okay, let's go ahead and get started. Hello, everyone. Welcome to our webinar under the algorithm, Your Privacy and Civil Rights in Housing. My name is Snigdha Sharma, and I'm a Senior Tech Equity Analyst on the Responsible AI team at the National Fair Housing Alliance, and also one of the authors of the paper. And I'm thrilled to be with you all today, and we're really honored to be joined by 4 wonderful panelists today. But before we get into that, I want to make sure that anyone new joining us gets an opportunity to know who we are and what we do at the National Fair Housing Alliance and Tech Equity Collaborative. This privacy paper was really a almost year-long joint effort by both organizations. So the National Fair Housing Alliance, or NAFA, is a long-standing national advocate for fair and accessible housing. And the Responsible AI team at NAFA holds both expertise in machine learning, computer science, and financial modeling for greater access and fairer lending. Conversely, Tech Equity Collaborative enters this discussion through their Tech Bias and Housing initiative, bringing us expertise into housing policy and systems change, with an ongoing focus on illuminating the tech industry's emergence and growing presence in the national housing market. Next slide, please. So before going into the panel, we're going to be doing just a little bit of housekeeping. We would really like this panel to be a safe space for learning, so please be respectful to your fellow attendees and panelists and their opinions. We want this to be a place where people are free to fully express their identities, and we definitely encourage questions through the Q&A feature, and these questions will be answered at the end. Additionally, the full code of conduct is in the chat, and it will also be enforced in the chat. And lastly, for ASL interpretation, please select the American Sign Language in the interpretation feature at the bottom of your screen if you need to do so. Next slide, please. Okay, so I'm very, very excited to pass it over to our panelists to give a brief introduction of themselves. And panelists, feel free to pass it over once you're done. So Prashant, let's start with you.
Yeah, hey, thank you for inviting and good to be here. I'm Prashant Sharma. I reside in the Bay Area. Currently, I'm the CTO for a platform called TechEquity. My previous background with Salesforce and Oracle before, designed a lot of products in there. Our current platform, TechEquity, our mission is to basically help businesses across their whole data lifecycle for security and privacy purposes.
Okay, from there we can go to Hannah.
I think Hannah is maybe not supposed to be.
Sorry.
It's okay.
Sam.
Yeah. Hi, everyone. I'm Sam Gordon. I am with Tech Equity Collaborative. I am our Chief Programs Officer, and really happy to have had the opportunity to work with NAFA on this paper. And I can pass to Michelle.
Hi, thank you all for joining us today. I'm Michelle Gilman. I'm a professor of law at the University of Baltimore School of Law. And one of the things I do there is direct one of our law clinics. And so I'm supervising students who are representing low-income people in a variety of litigation. And that includes housing litigation. So I have decades of experience representing tenants in housing matters. And over the decades, I've seen an increasing amount of automated decision-making impact the access our clients have to housing opportunities. So I look forward to the discussion.
And from there, let's pass it to Christopher.
Thank you, Snigdha. Good afternoon from Washington, D.C. My name is Chris Lee, and I am a principal privacy engineer with the MITRE Corporation. MITRE helps different government agencies figure out how to use data, process data in a secure and privacy-preserving manner. And AI has been a big discussion in that recently. Prior to joining MITRE, I was the first chief privacy officer at the United States Senate. And then before then, I worked for the Department of Homeland Security for 10 years. I was the privacy officer for the Sensitive Technology Directorate and worked on a whole series of emerging technologies ranging from biometrics to uncrewed aircraft. A lot of spooky and creepy technologies that I helped get out of the spooky and creepy into an actual reasonable use case. Back over to you, Snigdha.
Thank you so much, Chris. So as we get started with this discussion, I actually want to give this question to Sam. So Sam, as an author of this paper, can you tell us a little bit about how the paper came to be, the context and background around it, and really what the current challenges are to incorporating privacy, civil rights, and consumer protections into a unified, fair, responsible, and also coherent approach?
The simplest question. Yes, I'll do my best. So as Snigdha mentioned, we helped write this paper along with NAFA, and we started well over a year ago working on this. And just as a little bit more context for who we are at Tech Equity, we really think about how can we illuminate and address inequities that exist within the tech industry and also inequities that result from tech's products and business models. And we focus on that through an economic and racial justice lens. So the two areas we work the most on are housing and labor as two of the key drivers of economic equity issues. And so we had been really exploring this topic, as Snigdha mentioned in the opening, under an initiative we call our Tech Bias and Housing Initiative, which really examines, in particular, some of the nuances of how tech and emerging tech is entering the housing market for renters in particular, and how it contributes to some of the concentration of more and more corporations coming in to own rental units. And so through that, we've really looked at the use of algorithms and tenant screening, different types of landlord software that's come up, different business models that have come up to try and move people from rent to own. And through those discussions, we have talked to NAFA, who, as Snigdha mentioned, was really thinking about, financial modeling, responsible AI, how do all of these pieces come together? And, Snigdha, as well as her team, have a real expertise in computer science, data science, and thinking about some of the financial modeling. Our team has more expertise in the policy and thinking about how do these pieces of the law intersect and where are there gaps. And under the context of that, we started thinking about a lot of, the chatter that's happening, certainly around self-regulation, but also around the inability to test for discrimination, that there are these two poles, right? So it's either we're going to, sort of Trojan horse personalization algorithms and say it's going to help us test for bias, and therefore we're going to collect tons and tons of data that maybe don't need to be collected, or we're unable to see if there's bias happening because we don't collect that data. And so we said there's a different way to handle this, and could we really set out to think about how to wrestle that tension down and try to bring these two concepts into one conversation. And it became clear to us why not a lot of people have done that, because it's hard to get all of that into one paper and get it speaking to a similar audience. Because I think, we're really fortunate to have Prashant and Chris here, who are both privacy experts, and I think more technically well-versed than I am. And so I think often what happens is we all talk to the worlds that we know, right? Like we talk to policy folks, we talk to civil rights folks, and privacy folks, especially when we're doing technical work, tend to speak in a language that makes sense to everyone. So we really wanted to think about, could we bring these pieces together? Could we talk about the gaps in existing policy? Could we talk about how these privacy preserving methodologies could work to help safeguard when we do collect that data? And could we do that data collection from a data minimization framework? Could we hold all of these principles at once, essentially? So that's where it comes from. And I think one of the other things that's important to note is, like I mentioned, there's the financial industry and who gets a mortgage, there's tenant screening, there's rent to own. We really tried to apply a framework of common principles of how do we shift some of our thinking around how to enforce and design these protections in a digital age so that they could be applied across a variety of mediums. I'll stop there. Sorry, I know I said a lot, but hopefully that got close to answering some of what you asked, Snigdha.
Thank you so much, Sam. Yeah, we're hoping this could kind of set a bit of a foundation for the rest of the conversation. And remember, if you have any questions, to please just add that to the Q&A. So, Sam, one of the main things that you talked about was privacy preserving methodologies or privacy enhancing techniques. This is used or presented as a way forward in the paper to both protect consumer privacy, but also be able to use protected class data to test for discrimination. Christopher, you have a little bit more of a technical background, so I'd like you to explain what exactly privacy enhancing technologies are and exactly how effective they could be in ensuring that sensitive data remains confidential while still allowing for meaningful analysis. And while talking about these benefits, if there's the limitations that you've noticed as well.
Sure, and thank you for the question. So in regards to privacy enhancing technologies, short-term PETs, the term PETs is somewhat of a misnomer because a lot of these technologies actually reside on encryption, and that's a security issue. So it doesn't sound fun to say sets, it's better to say PETs. That's why privacy is thrown in there. But with security and privacy, quite often they go hand in hand. And if you were to look at what PETs are, if you were to look up a definition, say on Wikipedia, you'd see at least a dozen different types of PETs. There isn't any one particular type that stands out above the others, but there are a whole series of different possibilities. Most of them are connected using encryption, though. For most of those that are listed, they probably won't make it out of a laboratory setting because they're just way too complex. But there are a few we're seeing that are being deployed right now. Examples, two of them currently in use. One is called differential privacy. It sounds a lot like calculus, but it's really not calculus. It's actually very straightforward. Effectively, you're taking a large data set, and this is what the Census Bureau does. A lot of data on all Americans, and then they inject a lot of noise in that data set. They replace street numbers with alternative street numbers, zip codes with alternative zip codes. So you can still use the data for general demographic purposes, but it's preserving that privacy function within it. One other thing we're also seeing with privacy enhancing technologies, this is called secure multi-party computation, SMPC. There are a lot of acronyms associated with this, but if you look at secure multi-party computation, you have different parties with different pieces of information, and then they'll come together and make a decision. Do we share the data or not share the data? And one example you're seeing today is with the use of Apple Pay or Google Pay. If you have a smartphone, Apple Pay, Google Pay, you can hook up your credit card to your Apple Pay or Google Pay. And that way you have the information, Apple has certain information, the vendor you're going to, the grocery store, has certain information, and then there's a processor that has that information. They all have different pieces of information. They come together, they say, yes, approve the transaction, or no, don't approve it. Very fast, very efficient, usually happens within 2 seconds. And that's a nice way to preserve information and secure it at the same time. So how do you adapt some of those technologies to this fair housing issue? And we'll continue that discussion as we go forward today.
Thank you, Chris, for telling us a little bit about the more technical bits to protect privacy in this housing and lending context. So, Michelle, the question that I have for you is, in the current political climate today and where current law and policy is at, how do you think regulators can ensure that companies aren't using protected class information inappropriately while still promoting transparency and accountability? And is there currently anything in place to ensure accountability?
Sure. Well, here's some context at the start might be helpful. So in the purely analog era, it was possible to catch housing discrimination using testers. And these were people who posed as potential renters, and they would go around and apply for housing. And by sending in testers of different races or by other protected characteristics, it revealed whether or not a landlord was unlawfully discriminating against people. Pretty straightforward. Well, discrimination can be a lot harder to catch now in our digital society. Today, we know about 90% of landlords rely on some sort of tenant screening to select tenants. And when they purchase these algorithmically generated tenant screening reports, the landlord typically gets a recommendation as to whether or not to rent to a specific person, but the landlord doesn't know how the recommendation was generated or what factors went into it. To the user, the algorithm itself is a black box. And yet we have ample and accumulating evidence that these reports are biased, particularly against people of color and low-income people. And it's really important to recognize that a person's race, for instance, it doesn't have to be fed into an algorithm for that algorithm to have biased outcomes, because there are many, many proxies that stand in for protected characteristics. One easy example is zip code. If you know someone's zip code, you can often predict their race. Okay, so proxies we're very concerned about when it comes to tenant screening algorithms include criminal background records and credit scores. Both of those data points disproportionately impact brown and Black people due to lengthy histories in this country of over-policing and a lack of fair economic opportunities. So if tenant screening algorithms rely on those data points, and they do, and if there is no opportunity for individualized assessment of a prospective renter, which there usually isn't, it means that minority groups and low-income people are going to be screened out of housing opportunities. And for many of these data points, there isn't even a evidence-based, statistically validated connection between the data inputs and whether or not a person will be a reliable tenant. So the key question is, how do we protect against these biases? There are a variety of solutions, but let me talk about two tools that are potentially quite helpful and that relate to what Chris was talking about. And those would be to audit algorithms to assess whether they have biased outputs, and or to assess them before they're even deployed, a process known as an algorithmic impact assessment. And these tools would bring a lot of transparency and accountability to automated decision-making systems. As it stands now, however, they are not required by law. To conduct these sorts of audits, the auditors, whether they are the companies themselves, independent third parties, or government regulators, they are going to need some data on race and other protected characteristics of prospective tenants. And this use of data is perfectly legal under current law. Currently, tenant screening algorithms, as I just suggested, are subject to very little regulation. We absolutely need new laws and regulations to govern this industry. There has been some helpful action at the federal level. I'll give you two examples. The Department of Housing and Urban Development has issued guidance telling landlords and other housing providers it is not acceptable to deny someone housing based on an arrest record. And when it comes to conviction records, landlords still need to make an individualized assessment of the prospective tenant. The Department of Justice recently filed a statement of interest in a pending class action against an algorithmic scoring company that allegedly penalizes prospective renters based on their credit scores while failing to include the data point that some people are able to pay for their rent using federally subsidized vouchers, which makes them very reliable renters. So federal regulators are aware that the old school analog methods of ferreting out discrimination are just not enough in the digital age, and they are using various existing laws to try and address algorithmic discrimination. But it's pretty clear, and the paper suggests this, that we need some new statutes to enforce the new dynamics we're seeing around technology in society. Laws that were drafted in the 1960s just didn't foresee the digital society we live in today. I mean, That's pretty obvious and certainly no one's fault. And just a final note before I wrap up, it's not just up to federal regulators to police this landscape. Okay, our civil rights laws contain private rights of action, and they're very important. And it means that harmed individuals can bring their own lawsuits. Nonprofit organizations that work with harmed individuals can bring lawsuits. And these private rights of action are really essential to expand the capacity for oversight and enforcement. We have to recognize government regulators alone have limited capacity. So we're really looking at what needs to be a joint effort across various sectors of society. And I will end there.
Thank you so much, Michelle, for that detailed explanation. One of our recommendations in the paper was learning from these examples where these two tensions are not correctly calibrated between privacy and civil rights, and really analyzing their consequences to see what we can learn from them. And so going off on that, I'd love for you to chime in as well, Chris, and then you, Sam, maybe on the balances that we talk about in the paper.
Thanks. Just adding on to Michelle's comments, Michelle mentioned this black box approach where these algorithms are usually just programs that decide either you get the application approved or not approved. They go into a black box and nobody can explain how they work. In the European Union, they've got a draft bill called the Artificial Intelligence Act, which prohibits this type of black box approach. It requires transparency where the algorithm developers have to explain how does it work and why are certain people being included or excluded in these decisions. And that's likely going to start happening here in the United States as well. So that's one thing you'll see. And also adding on to some of your comments in terms of looking at how do you make this work from an engineering standpoint, usually what they're looking for is a baseline. How do you measure what the harm is? And then what's the goal to change that? How do you improve the process to get to a better standpoint? And if you can put that in metrics, then you can usually improve the process going forward.
I was just going to add, because I thought Michelle did such a beautiful job laying this out, that one of the other things that's really stood out to us is, some of the current contours of regulatory jurisdiction and regulatory action are also tricky in this space. So for instance, on tenant screening, the Consumer Financial Protection Bureau has the authority to regulate 3 of the major providers of tenant screening because they have the authority to regulate some of those providers because they do credit scoring. But they issued a report, I think last November, that estimates there's over 600 other tenant screening companies that are providing this service to landlords, and they're kind of nowhere within our broad regulatory structure unless individuals know they have experienced some form of discrimination, as Michelle was saying, and use a private right of action or file a complaint with the appropriate housing authority where they live. So that's something that we've tried to sort of speak to in the paper, is that there has to be an awareness that in this digital age, these protections, they need to be somewhat nimble and somewhat intersectional. And I know something that concerned us is earlier this week, we saw a ruling from a federal judge in Texas that said that the CFPB does not have authority to regulate around issues of discrimination as a consumer issue. And so these sorts of trends make us nervous because this discriminatory outcome has to be clear to the public, because as Michelle said, and as Chris spoke to, we don't have explainability clauses right now for algorithms, right? And hopefully we will get them through campaigns and policy work, but it's really, really important that not only do individuals have private rights of action and can step forward and bring, claims when they are harmed, but also that regulators take a proactive approach, because individuals will often not understand that this is happening. And so one of the core things we advocate for, and I don't mean to jump ahead, Snigdha, in the paper, is a shift from putting all of the burden on individuals, is saying give individuals tools, but also let's shift some of that responsibility to regulators and to private companies to prove, as Chris was saying, that, these you can prove the logic, you can prove the decision. And to Michelle's point, for people to be able to explain pre-deployment on the public, especially in things like housing, which is a critical need, that your tool is not going to create harm. So I just wanted to add those pieces as part of our perspective on the regulatory landscape, I would say.
Thanks, Sam. I appreciate that. And a lot of these solutions that we've been hearing, impact assessments, explainability, analyzing outcomes, we've been seeing a lot of that in the AI Bill of Rights, which is, definitely on the right track, but it isn't hard law. So it's hard to actually, hold industry or companies accountable for their actions. So that's really the next step of what NAFA and other civil rights organizations are advocating for. So we've talked a bit about privacy enhancing technologies, but another main pillar of our paper is data minimization and how we can use these privacy enhancing technologies within the context of a data minimization framework. So Prashant, I'd actually like to ask you what exactly data minimization frameworks are and how they can be applied without compromising the actual integrity of anti-discrimination testing.
Yeah, so thanks. Data minimization is nothing but like you are basically collecting the least amount of data needed to make any decision. Essentially, that's what it means. You are only collecting data which is meaningful for your business purposes, and any extraordinary information from which you can make a reference, so those are discarded. The thing is, because if you're collecting this data which is beyond your purpose of scope, then you can introduce bias, and then you can basically introduce like harmful purposes by using this information. So there are several ways to like ensure that you have the minimized data available. So PETs actually allow you to enable some of these mechanisms, like in case of like housing, like if there is a use case like where you want to I want to know the age of the tenant. So you can, instead of collecting the exact age, you can set up like a range, and you can collect that range value. So you don't know the exact age of a person, but if it fits that particular age range, you are okay. You can also look at, hey, do I need to know what is the exact employment history of this person, right? You don't need to know that. What you need to know, you might need to know is whether this person is employed for last 2 years or 3 years, right? To make a decision. So this is what data minimization does. It essentially focuses on what you need information as a decision maker, but you are not collecting the exact set of personal information from that individual. Okay. Now there are several mechanisms to ensure this, like to ensuring like data minimization. So in the paper, like there's a talk about like differential privacy where you introduce some noise, where you can ask like some sort of questions. So there is like a different kind of differential privacy. I think paper doesn't go into detail, but there's like a standard differential privacy. There's a local differential privacy, like only to use cases. So I'll briefly touch on this. So standard differential privacy is more focused on like analytics and ranges and all that. I don't need to know anybody's age, but I need to know the age range. I need to know the salary range. I need to know whether you are living in a particular zip code radius. I don't need to know your exact zip code. So differential privacy like allows you to do some of these mechanisms, and you don't have to disclose information that way. The other technique which is mentioned in the paper is called a federated learning. So federated learning is nothing but you have basically the information not at one place, but at different places. And you are basically making analysis by combining these groups all together. So you get like aggregate information, not an individual information. So depending on the use case, you have to pick whether you want differential privacy for an individual or you want aggregated information using federated analytics. On-device computation, what Chris talked about, where Apple is making the decision local on the device, that is also a great technique. The limitations for that is like you can only make certain decisions on the device because the device has a limit computation power. If you want to go into broad use cases, then yeah, you have to think other mechanisms of federated learning will come in. So these are like some of the mechanisms. Based on the use case, you can pick whether I want to go for differential privacy or I want to focus on analytics. I can, do federated analytics. Or if I have a simple use case, I just want to know about this person, collect some analytics, I can do on-device compute, then I can, send it out. So these are some ways you can do data minimization. These things are evolving as times are, this is a pretty evolving field, things keep on coming in. But as we see more and more automated decision making, so these are some of the ways where you can basically ensure you are having data minimization and you have a fair use case and fair use, you're minimizing the bias there. So.
Thanks, Prashant. Over to you, Sam.
I was just going to add to, obviously I'm a hammer, so everything's a nail. So I'm adding policy here, but, on the data minimization front, I think one of the other pieces, in addition to what Prashant was laying out, is one of the things we're advocating for from a policy perspective is really narrowing, even to start, not just in, to Prashant's point of like broad age ranges versus you need to know this exact age range, is really challenging what is really needed for the business, what's a justifiable business purpose, and making sure that companies can, legally defend that position and are ready to defend that position if it comes to it. So that's one of the things we're really focused on, because we've seen examples, and we included some in the paper where, maybe a data point was collected for a particular purpose. We included an example from Meta, nay Facebook, where, people had put in their race for one purpose and then it was used for other purposes. And then down the line, there was a racial steering case that ended up investigated by the DOJ. And so really thinking about data minimization is like, first, is it justifiable to even collect this data? And then second, how are you controlling the use of that data? So really we're calling for, if you've collected data for one particular business purpose, that's justifiable. You'd be happy to defend that in court. Like you stand behind it. You can't then extrapolate and use that data for something else that people haven't given express consent for, partially because the data inequities that exist right now in our system is there's a huge trove of data that's concentrated into, a handful of companies. And then folks aren't necessarily giving their consent for how that data is sold and shared and used. So that's one of the other angles that we've tried to bring kind of to light through this paper, is that data minimization, we hope, means really controlling what we collect to start, and then also how that data gets used in the future, in addition to a lot of the technical things that Prashant was laying out, which I think are good.
Thanks, Sam. Prashant?
Yeah, good point. With the coming of the large language models and like ChatGPT and other use cases, what has happened is now you can send them any kind of data. And the good thing about ChatGPT is they're constantly learning. There's no stop. So they can evolve over a period of time, but they can ingest data in what is called a multi-mode media. So you can send like your CSV files, you can send your documents, emails, images, and the large language model will learn from it. It becomes very tricky to actually monitor like what data is being collected and what is the purpose of use. The tools are still evolving on this. This is a fairly new field. So the businesses have to be very cautious on what data you're collecting, who has access to it, what is the purpose, because there are different teams in a company, different departments in a company. And now it is much harder. Now anybody can, get a prompt out and then extract like, hey, do you own a Tesla? Right. So it is very easy for me to ask that question, and I can derive further information from that. So you need to also invest in like what is called a data inventory as a business. Like what data are you collecting across departments? And I would suggest that for doing data inventory, focus on something which is not manual, because you can't keep on writing rules for the data you're collecting. So the system has to tell you like, this is the new data coming in, what you're collecting. And by the way, it has personal or sensitive information. And then you can see what is the purpose internally I'm using in my company. And then you can take the next steps from there.
Thanks so much, Prashant and Sam. So I really liked what you said about user consent, and that kind of brings me into my next question. So we know that algorithmic discrimination occurs, and a big part of the paper is shifting the responsibility from the consumer to actual industry and to the regulators. But I'm sure consumers would like to know when an algorithm is being used, especially if it's affecting them, for what, and from that case, if they've been unfairly affected by algorithmic discrimination. So this is a question I want to pose to all of you about how exactly consumers could be aware if algorithmic decision-making is being used, and if it's possible to even identify if they've been affected by algorithmic discrimination. And we'll start with you, Michelle.
All right. Well, I can give you sort of a grassroots perspective from the viewpoint of a legal services lawyer. And we definitely have clients who are struggling to obtain housing. They're going from, going online from development to development to building and not getting housing, but they don't know why. They also are terrified if they're facing eviction, not just of losing their home, but they're very aware that that eviction record could keep them from ever obtaining housing again, because it becomes a data point in a tenant screening report. So that's what we're seeing, but it's very hard. It's impossible to know, is it discrimination? Is it an accuracy problem? Is it something else entirely? Because there's a complete lack of transparency here, right? There are several layers of opacity that we are facing from sort of this ground level view. Okay, most tenants are not going to know that the reason they were denied was based on a tenant screening report. They're just filing applications, as I said, and hoping something comes through. And these applications are expensive because they pay the cost of the tenant screening reports that the landlords require. Although the Fair Credit Reporting Act, sometimes called FCRA, does require landlords to provide an applicant an adverse action notice if they have used a consumer report that leads to rejection, the reality is the vast majority of landlords do not provide them. And even if you get your hands on one, there's no explanation required in it. And Chris talked earlier about how important, an explanation can be. So there's really no transparency there, and it's not very helpful. Even if, as a lawyer, I could, get my hands on some explanation and try and move forward, it's very likely that the algorithmic vendor is not going to reveal their underlying methodology. They're going to claim trade secrecy. They want to maintain their proprietary advantage. Even if I could get past that hurdle, there are some machine learning algorithms that are so complex, even their makers can't really explain their outcomes, which raises a very good question of whether those sorts of algorithms should even be allowed in these spaces where they serve as gatekeepers to people's life opportunities. So there are many, many barriers to uncovering discrimination. And this is exactly why we need impact assessments and audits and a regulatory approach. But just noting again, they are not legally required at this time. So I will end there on that.
Thank you, Michelle. Sam?
I was just going to add that, ditto everything Michelle just said. And this is part of the reason that we need those pieces of policy added. And we also need the proactive engagement of regulators, and we need companies to set a higher standard, right? And really think about these privacy enhancing technologies, think about data minimization, think about a justifiable business purpose. One, because it's also strategic for companies. I think Chris was sort of saying this earlier, like, what's happening in Europe is going to happen here. That's my belief. That's my will. I will, but I think that for companies that want to stay on the cutting edge of this, and I understand that there might be different impetuses for change inside a company, but I think it's also to companies' benefits to think really critically about this, because I think they will be open to a lot of liability if they're not, as this continues to evolve and change. And I will also just say, to echo Michelle's point of consumers often don't know, a lot of what we know is from journalists, is from leaks, is from litigation. And so that to me alone screams that there needs to be better transparency and better understanding for consumers. And there are a variety of things that we pose in the paper that companies can do and that regulators could do to bring that transparency to life. Because there's also a question of, like, we agree on impact assessments and auditing. We also have questions about, to Michelle's point about these LLMs that people can't explain. There are some cases where, like, should you use this technology at all? Right. And I think that is also an important conversation that needs to happen in a democratic and, public space with lots of stakeholders that aren't just companies or engineers or computer scientists, but impacted people, and really thinking about, when is the use of these pieces of technology appropriate and when is it not? And then for the ones that are approved, how are we testing them before they go? How are we auditing them? So I just wanted to add that on.
Thanks, Sam. And I really liked what you said about how industry also needs to critically think about starting to kind of implement these solutions, because even if there is no current, national overarching law, a lot of these states or cities are starting to have their own laws around algorithmic protections, and those standards differ. So it's harder for companies to legally be able to function in those different cities and states when there are different standards when it comes to algorithmic accountability. So something that we've been noticing is, it would even be easier for them to just adhere to one overarching standard than deferring standards when it comes to state or citywide regulation. And from there, I'll pass it over to Chris.
Thanks. So taking a different approach, one is looking at what are potential solutions that are being considered. And for some social media platforms, they're looking at requiring a tag being added to, say, a photo that's been enhanced digitally by AI. And that way, you're looking at something that's different from the original photo. That's one possible approach. But one of the other challenges that is, one question you want to ask is there a harm associated with digitally enhancing a photo? And on the one hand, if you look at a magazine cover, almost all magazine covers of people have been enhanced. Usually not a whole lot of harm involved with that. But there are other situations where people are taking photos and then transposing the head onto an inappropriate figure, unclothed figure. That would be totally inappropriate. And there should be protections with that. There are certain federal protections and state protections for that currently. But there needs to be a better, easier way to approach that and deal with that. And those are areas that the ethicists, the technologists, and the policymakers have to come together and find a solution to address this issue before it gets too big. And it goes beyond fair housing to many other areas.
Thank you, Chris. Over to you, Prashant.
Okay. So it is very hard for consumers to know whether they are impacted. I believe the only way is you can submit a data subject request that give me all the data you store on me, and based on the state, if it is California, so under CPRA, you'll get your data. Otherwise, it is really hard for customers to know whether they have been discriminated. On the business side of things, on the other side, so few companies are tackling this, there is a concept called a model card. So I basically publish okay, this is how the algorithm basically works. These are the bounds and ranges. And I've also seen few companies where they are saying that, okay, if there is an error, you have been denied, or let's say we have a low predictability that you could be denied something. So a human will come in and review your application. So that way, you can also ensure trust. For the current setup, LLM, a large language model, they run at billions and trillions of parameters. So it's really hard. But there are efforts now to introduce explainability into these systems and checkpoints. And several cloud providers, several applications are working, several platforms are trying to introduce this. It will take some time, but we're trying to have the LLM explain why did you derive or come to a certain conclusion. Explainability is hard. It requires extra effort. There is cost involved, but I think it gives businesses an advantage because now we are more trustworthy. As a tenant screening platform, I am fair, I am unbiased. We'll give you a reason why you were denied. So that will actually be a bonus point. If you have so many tenant screening companies, I would actually use this for selling my product that, hey, we are fair. So that's it.
Thank you so much, Prashant. And thank you to all of the panelists. I know as we talk about this and discuss, I just have more and more questions. So at this time, I'll actually turn it over to Marian Wellington, Director of Comms at Tech Equity Collaborative, for questions from the audience towards the panelists.
Great, thanks, Snigdha, and thank you so much to everyone. I feel like I've learned so much in the last 45 minutes. And it seems like our attendees have as well. The Q&A has been popping, so thank you all for sharing such great questions. I'm going to start with a little one-on-one question from earlier in the conversation. Chris, you mentioned that pets are also actually sets, like security versus privacy. I was wondering if you could spell out what the difference is between privacy and security and how they relate to each other.
Sure. Usually, privacy is broadly defined as being able to control data about yourself. And security quite often looks at a broader picture. They look at all data, whether it's about personal information, your own personal information, It could be about computer information. It could be about computer traffic. Then how do you secure all that data? So there are complementary goals, but there are different approaches to reach those goals. Security tends to be a little bit more technical, and privacy tends to be a little bit more liberal arts oriented. So that's where you marry the arts and the science together to come up with a solution.
Great, thank you so much. And I also have one little logistical question. Someone asked what the California opt-out for data thing is, and if someone can explain that a little more.
Do you want to do it, Prashant, or do you want me to do it?
You should, yeah, I think, yeah. Why don't you start? I'll add it.
I can try. There's a couple privacy laws in California, but the one that Prashant mentioned is CPRA, the California Privacy, I forget the acronym, something, CPRA.
Rights Act.
Thank you. Rights Act. And so through that, you can request of any company the data that they're currently storing on you. So that's what Prashant's referring to. So every company that operates in some form in California is supposed to legally have a process. Usually you can find on their website where you can submit to an email, or some of them have a form that says like, I'd like all the data you're storing about me. And some of them you can ask for, you can try and get that explainability of like, if it was used in any sort of decision about an outcome within your company, can you tell me what information was used? So there are different ways that you can do it with a company, but that's essentially broad strokes what it is. And Prashant, you should feel free to weigh in if I missed anything or misinterpreted.
No, this is good. Yeah. So CPRA is one of the laws. It allows California residents to delete their data. And under the new law, you also have the right to like opt out of sale. There are a lot of new changes around correction of your data. You can ask companies to correct. There's a portability law where you can say, I want to move from this provider to that provider. So can you move my data? So as a consumer, you have the right to all of these, and there's no charge for it. As a consumer, you can ask the businesses to do it. And they have all the businesses have a finite amount of time. They have to respond to your request, whether they will fulfill it or not, but you will get an accurate answer within that time frame. And if you want to like exercise this, so typically if you go to any company, they will have like a privacy policy section or terms of use section below on their website. Or they will have a do not sell under California law, like they'll have separate buttons, and then they'll have a mechanism there like call us, email us, or use this form for your privacy request. So those are mechanisms how you can exercise this. Yeah, please go ahead, Chris.
Thanks. One other thing to keep an eye on, the California Privacy Commissioner's Office just released a draft for the California Privacy Protection Act, CPPA. This is released about 2 weeks ago. Inside that draft, there is some discussion on algorithmic bias, and they're seeking comment on that. So we're still looking at a slow drafting process. We're probably looking about another year before it's finalized, another year before it's fully implemented. But if California does this, that will be one of the first large states to do something about algorithmic bias.
Great, thanks so much. We have a question here, and I think this maybe is best for you, Michelle. How do arbitration clauses play into enforcement? So if someone can surpass all of the obstacles to finding that, yes, they have been discriminated against, can they go to court or form class actions? What do they do?
Yes, I don't see arbitration clauses as a barrier here because the tenants aren't party to any agreement. The agreement is between the algorithmic vendor and the housing provider, usually a landlord. The tenants aren't party to it. So there's nothing in those terms that bind them. So yes, we have seen litigation around these. There have been many people who have gotten their hands on the screening report and found all sorts of inaccuracies that have led them to be denied housing, and they filed defamation lawsuits successfully. And there have been a handful of civil rights actions around these issues. So there are many barriers. I have not heard about arbitration being a barrier, but if anyone else has heard about this, let me know. I don't see how it would come up in this context, but it's a great question.
Yeah, I was going to say it'll definitely come up in the labor context. So as we're developing our tech bias and labor initiative, feel free to check back in and we can talk to you about how arbitration is going to play a role in that. But yeah, I think in the housing, I haven't seen it.
Great. And thinking about algorithmic bias, rather than just these piecemeal or I guess patchwork lawsuits to try to address it, how can we address algorithmic bias on a more systemic level? Policy ideas, anything? Welcome.
I think there's a few things, and I know lots of folks on the panel probably have thoughts about this, but I think first and foremost, we have laws on the books for discrimination and disparate impact. So if there is discrimination, whether it results from an algorithm or a human's interpretation of a predictive model or just a human, it's discrimination. And so I know, here in California, we have a California Civil Rights Department. They are fully authorized to investigate any form of discrimination around housing, employment, and some other things. So I think, one, we have laws on the books to tackle it if we know it's happening. Part of the impetus of the paper is that we often don't know it's happening. And so that's part of the idea of getting, the impact assessment so that companies are incentivized to reduce and mitigate the potential for bias and discrimination, and 2, for transparency, 3, for explainability, because consumers, as we've been discussing throughout, often don't know. So I think, 1, if you sense that you're experiencing discrimination in housing because of one of these tools, complain to your housing authority or your civil rights department. You can complain to your local authority because they do have the power to investigate that if there has been discrimination. And then secondly, I think, the policies that need to be enacted, there's a variety of proposals. I think with the emergence of ChatGPT and suddenly people understanding that AI is a thing. And a lot of us have been like, it's been a thing for a long time, but it's coming to the public consciousness in a different way in the last year. I think we're going to see more and more proposals around dealing with algorithmic bias. I know here there's rulemaking that's being planned for the housing and the labor side on automated decision-making systems and how to deal with algorithmic bias in them. And then obviously there's a variety of frameworks and proposals being put forward in DC. I'm sure Chris could speak to better than I can of all of those that are coming forward.
Sweet. And while we're on this topic of algorithmic bias and how we can tackle it, Michelle, do you see independent algorithmic auditing as a solution to help mitigate some of this algorithmic discrimination? If so, how can these independent auditors navigate these issues in a way that is really impactful?
I think it's one important part of a multi-pronged approach, which is the beauty of the paper, shows there's no silver bullet here. We need multiple parties doing enforcement. We need multiple strategies, but clearly algorithmic impact assessments and audits would shine a light on this and bring such needed transparency into this space. In terms of trade secrecy, I don't really see a problem here because we're not asking a vendor, put your source code on the internet, right? Just give it to the auditor and there could be some sort of confidentiality agreement. So the whole purpose behind a trade secret, which is, to protect your proprietary advantage, isn't threatened by an independent professional auditor or government agency having access to your black box. So I think that's a red herring and we shouldn't fall for it. I know in the court system, courts, when analyzing algorithms, will sometimes require that they be turned over subject to a protective order. It's that same idea. Let the people who need to see it, see it. No one is asking you to share it with the world. So let's not fall for that.
Hear, hear. We have a couple of questions about the data minimization framework in general. So I want to pass this over to Chris and Prashant. First, just to clarify for folks who may not know, does the data minimization framework include a requirement that consumers consent to the collection of their data? And then second, how do these organizations, so part of the definition of a data minimization framework is ensuring that the data that they collect is narrowly tailored to a specific justifiable purpose. How do organizations that are collecting data do that?
I'll start. So in terms of data minimization and consent from the consumer standpoint, usually consent is required. You are required to go through a user agreement and then usually check yes at the bottom, could be 50 screens long. You really don't have a choice in that situation. In legal terms, that's usually referred to as a contract, adhesion contract, where it's take it or leave it. Either you say yes and you give up your data just to get access to the software, or you say no, you don't get access to anything. That doesn't seem very fair. There's not a whole lot of negotiation going on, but that's the unfortunate situation we're currently in. But usually there is some level of consent that you do agree to consent. It should be narrowly tailored, but quite often it can be very, very broad. In the earlier days of smartphones, quite often a lot of these apps weren't just collecting your user data, but they're also looking at your phone calls, your text messages, your pictures, and collecting, just hoovering up all that data and using it for various purposes beyond their original intent. A lot of that stopped, but there are still situations like that, and it's a challenge to try to keep that in check. From a company standpoint, one good reason not to collect too much data is if you don't have the data, that means you can't lose it and you're not liable if there is a data breach. If you do have it, there's a data breach, you're probably going to be paying a lot of money for that data breach. So keep that in mind as a cost-benefit analysis as you go forward.
Yeah, so adding to that, yes, so less data, your cyber insurance will be low actually, if you have less data. And then if you have a lot of data to collect and use, so you might want to think about like maybe after, like what is your retention for that data? Because the longer you keep the data, then data retention comes into picture. Data access is an issue, like who all can see this data? Like if I'm a patient and let's say I create a ticket for you, is my whole support team looking at that ticket, or only like your physician is looking at? So those are like some of the processes you have to follow on the access side. You can basically collect the data and then say that, okay, after your request is served, I'm going to anonymize the data and then, you know, let it go for my other analytics purposes. That is one common way to serve on this. On the customer side, like they can always say like, okay, I agree to this, but then if you're a California resident, you can always say, I want opt out of sale. So you can sell that data to third parties. So those are like some of the mechanisms on the customer side they can follow. The business has to make sure they have processes to allow data minimization, like opt out of sale or data correction or portability. So I will say like, you keep it for the minimum amount of time for the retention purposes. And once you're done with that purpose, let's either discard it or you can anonymize it so that, you know, it's safer for you and even for the customer. So.
Great, thank you. Snigdha, I'm going to ask one more question if that works for you, and then pass it back. Great. So obviously this is a huge conundrum on many levels, policy, corporate practice, just as a whole. So for those of us that are at home that want to know what we can do, does anyone have any advice on ways that people can participate to strengthen their privacy and civil rights in housing?
I have thoughts. I don't know. Michelle, do you want to go first?
I don't care about going first, but I would say if you are being denied housing and you don't know why, you do have some rights to get an explanation. If you cannot afford a lawyer, call your local legal aid bureau or fair housing organization. There are people who can help you with this, who want to help you with this. And your action alone helps not only you, but everyone in bringing more transparency and accountability to these systems.
I will add to that and say also, if you're, not necessarily experiencing this, but you care about this, you want to make sure that, the sort of innovation and digital speed of our world does not create more and more harm for people, in particular for vulnerable people. Come into the discussion. I think one of the biggest problems is right now, there's a lot of gatekeeping around who's allowed to be in these conversations and who's allowed to have expertise about it. And I think that that's garbage because all of us are impacted by technology. So you do not need to be a computer scientist. You do not need to have years of experience with data to be able to say, this concerns me. And here's, where I think this could be harmful in my life, in the life of people I love or care about, my neighbors. And so you can do that in a variety of ways. One, you can, read about these issues, stay up to date. Two, you can get involved with organizations like ours, like Tech Equity, which pays a lot of attention to these policy issues and creates agendas to help try and move structural change, at the industry level and in public policy. And three is, if you see a proposal you believe in, contact your elected representative and tell them that. I think one of the, I'll just say again, one of the biggest problems is that there's been an intentional campaign led by, a handful of executives at major existing tech companies to say we are the only ones that have the expertise to weigh in on this. And I think that's deeply problematic and untrue.
And I'll pass back to Snigdha. Oh, sorry, Prashant, do you want to go ahead?
Yeah, just like 30 seconds. So I think as a consumer, people need to be aware of what data they are sharing with different, software platforms. And in a lot of scenarios, if you don't think like, this is appropriate, you can always reach out to the business and say, hey, I want you to delete my data, or you don't have the right to sell my data. So I think it's more of a consumer awareness. And then the businesses will start taking notes because they will recognize that they're losing that particular customer. So that is probably like one of the ways. So consumers needs to be more on the forefront of this.
Absolutely. Thank you all. I'll pass back to Snigdha to close us out.
Yeah, I believe we're at the end of our time here, but I want to say thank you to all of the attendees for joining us and for your very thoughtful questions. Thank you to all of our panelists for bringing their incredible insight and experience to this webinar. We had a really great discussion. And for the attendees, remember to look at the paper if you have any more questions or want to learn about some of these things a little bit more thoroughly. As a reminder, this discussion will be recorded and will be shared with all of the registrants afterwards. And I hope you all have a lovely rest of your day. Thank you so much.
Thank you
Thank
all.
you. Have a good afternoon.
Thank you.